All right, it's 6 o'clock. Good evening, everyone. This is Delsteady Merced. Today is Tuesday, May 15th, 2018. This webinar is being recorded. I know some of you had probably got stuck in that weather and probably rushed to get home to join us this evening. Hopefully everyone is safe. Fast-moving storm, but a terrible storm. As you know, as always, there are a few important items that I have to review before we get started. I believe just in case, I just want you to know that this webinar is being recorded. If any of your colleagues happen to miss tonight's presentation because of the storm, they will have access to the recording and can make up the program by viewing the recording. First, an affirmation form was included in the email I sent you with the training outline. At various times throughout the webinar, there will be various codes displayed on the screen. These codes can be numbers, a combination of words, or both. You must write down the codes on the affirmation form. The codes will not be read out loud. Again, I repeat, the codes will not be read out loud. The course code will now be displayed on your screen. Mark, can you move forward one?
Yes.
The course code is now on your screen. Please write the course code number on the affirmation form. I will keep it up there for the duration of my opening remarks. Submission of the affirmation form with the correct codes is required by the New York CLE board and by NYSED for continued certification as a hearing officer. Please keep in mind that only hearing officers who participate in the entire webinar session would meet the training requirement and are eligible for CLE units. CLE credit will not be awarded, and the training team cannot attest to your participation unless the codes submitted on the affirmation form are correct and you viewed the live program for the full 2 hours. Partial participation will not be accepted. GoToWebinar tracks the time a participant signed on and off to view the program. I must receive the affirmation form by no later than Friday, May 25th, 2018. Again, that date is Friday, May 25th, 2018. Affirmation forms received after this date will not be considered for CLE credit, and New York State Education Department will be informed that you have not met the training requirement. Second, all participants will be muted throughout the duration of the webinar. It is our purpose today to answer as many questions and to receive as many comments as time allows. Should a question or comment come to mind during the presentation, we ask that you share either the question or comment using the control panel that popped up when you logged in to GoToWebinar. In that control panel, there's a question dialog box with the wording, type questions here. We will pause to take questions or comments throughout the 2 hours as time permits. This evening, as you might have heard, we will be joined by Lynn Beekman. Finally, as I indicated in my email attaching the webinar materials, at the conclusion of the broadcast, a window will pop up that will give you the option to submit feedback through GoToWebinar. Please take a minute or so after the program to fill in the feedback form. I have one more item that I must review before tonight's featured presentation. The United States Office of Special Education Programs, OSEP, has requested of the New York State Education Department that it review with its IDEA hearing officers when a decision is due after an extension of the 45-day timeline has been granted. NYSED has requested of us that we review this information with you. When the parent files a due process complaint, the IDEA and its implementing regulations require that a final decision be reached and mailed to each of the parties not later than 45 calendar days after the expiration of the 30-day resolution period or the adjusted time periods described in 34 CFR section 300.510C. There is no provision requiring a resolution meeting when an LEA, a local education agency, is the complaining party. Since the resolution process is not required when the LEA files a complaint, the 45-day timeline for issuing a written decision begins the day after the parent and the state education agency receive the LEA's complaint. Under IDEA, a hearing officer may grant specific extensions of time beyond the 45-day period at the request of either party. In New York, the timeline for the hearing officer to render a decision is consistent with the federal timeline. The hearing officer may grant specific extensions of time beyond the 45-day period at the request of either party, but each extension must not exceed 30 days, and the hearing officer must consider the factors found in section 200.5 J5 2 and 3 of the regulations of the Commissioner of Education as appropriate. Moreover, pursuant to section 200.5 J5, when an extension of the 45-day timeline is granted, the decision must be rendered and mailed not later than 14 calendar days from the date the hearing officer closes the record, or not later than the last date of the extended timeline, whichever date comes first. I repeat, when an extension of the 45-day timeline is granted, the decision must be rendered and mailed not later than 14 calendar days from the date the hearing officer closes the record, or not later than the last date of the extended timeline, whichever date comes first. Let's take 3 examples to make the point. In each example, the hearing officer granted a 30-day extension. In example 1, if the hearing officer closes the record on day 7 in that 30-day extended period, his or her decision would be due 14 days from day 7, which would be day 21, i.e. 7 plus 14. In this example, the hearing officer does not have the benefit of the additional 9 days left in the 30-day extended period. In example 2, the record is closed on day 16 in that 30-day extended period. Under these facts, the decision would be due 14 days later, which would be day 30. In example 3, the hearing officer closes the record on day 20 in that 30-day extended period. Under these facts, the hearing officer would have only 10 days, not 14, to render and mail his or her decision, because the decision is due not later than 14 calendar days from the date the hearing officer closes the record, or not later than the last date of the extended timeline, whichever date comes first. The hearing officer determines when the record is closed. Once the record is closed, no further extensions of the decision timeline may be granted. With that, I'm turning this over now for the featured presentation. Mark, you can take it over.
Great, thank you. So what we're going to do is begin with talking a little bit about what it is we're going to be talking about. But before I do that, I did want to mention that I'm honored once again to be here and be able to talk with you all. And I do encourage everybody to submit questions through the software that we've got here, and we'll try to answer as many as we possibly can. Your comments are really what we're looking for. But I'm hoping that what we'll be able to do is cover the most important topics in connection here with tuition reimbursement as a remedy under IDEA. In some ways, this is a little bit of a companion to the piece we did previously with prospective relief under the IDEA. Here we're talking about a form of retroactive relief. And so the idea is to try to cover a lot in the way of remedial issues having to do with special ed cases. What I'm hoping to accomplish here is to talk a little bit about some basics, although since you've had, I think, a lot of programming on that, we're going to move over that pretty quickly. Similarly with whether free appropriate public education has been offered in a given case. obviously that's something that you're familiar with and that you've been dealing with quite readily and quite regularly throughout the time that you've been a hearing officer. Probably the things that come up, say, a little less frequently, or in which you might want to have some discussion with your colleagues and with us, would include topics about, say, the appropriateness of the parent's chosen unilateral placement, and also the consideration just of reimbursement as a matter of equity, which can affect both the right to reimbursement itself and the amount of reimbursement that winds up being offered. So with that then in mind, we can kind of launch into the next slide, which is slide 4, and that's this topic of tuition reimbursement basics, the Burlington-Carter test, the 1997 amendments to IDEA, and Forest Grove. Really quickly, just with regard to Burlington-Carter, I think everyone knows the Supreme Court, without really the benefit of any specific codification on the part of Congress, decided quite early on that tuition reimbursement would be a proper remedy in special education cases, both by courts and by hearing officers. And so that's the Burlington case originally, which was actually kind of a convoluted dispute over which agency was going to pay for a kid's residential placement. And then the Carter case, which was a somewhat, I don't know, maybe a little more typical case involving a kid who was served in a private school, but the private school was not on the state's approved list of schools, and the parents still wanted to get reimbursement. In Burlington, of course, the court said that, well, as long as the appropriateness of the placement that the school offered, as long as that has been shown not to be the case, and the parent's placement has been shown to be appropriate, then that supports a reimbursement remedy. Carter basically said the same thing, although it did also add a little bit to it, not only with the idea that the fact of approval in and of itself is kind of immaterial one way or the other, as long as the placement is appropriate, but also saying that, you know, it's then up to the court or the hearing officer to provide a remedy, and we're not saying that, say, the amount of tuition reimbursement couldn't be reduced if the amounts were not reasonable, the amounts claimed or paid. We're leaving this open as a kind of open-ended remedy out there. Sure enough, Congress then acted, not exactly on that invitation, but nevertheless acted when the rest of the IDEA was revised in significant part in 1997 and put into place a tuition reimbursement remedy. On the one hand, they put in provisions dealing with services for kids whose parents had just voluntarily placed them at a parochial or other non-public school, which had always been in the law, but was not quite as clearly spelled out as it was in 1997. And then provided, kind of as a companion to that there'd be remedies available for tuition reimbursement precisely under the statute itself. If you're looking at the outline that we sent around, you'll see that I've reproduced the guts of the provision here on reimbursement for private school placement. If you looked very carefully, you probably noticed that somehow in my dragging and dropping, I managed to drop a line. So whereas double I reimbursement for private school placement provides generally for the remedy, 3, limitation on reimbursement, there is a line missing that should read, the cost of reimbursement described in clause 2 or clause II may be reduced or denied if, and then those are the provisions AA, B, ultimately Roman numeral 2 in parentheses, Roman numeral 3 in parentheses, providing for notice requirements, providing that there's a possibility of a judicial finding of unreasonableness that can yield the reduction or denial of reimbursement as well. You know, obviously that does codify things, maybe makes things a lot clearer. It does have the glitch in it, potentially, that it provides for reimbursement when the child has been served previously by the school district in special education and didn't provide a remedy where the child hasn't been. And it took the Supreme Court in the Forest Grove case to say that, well, we don't think that Congress's codification of the rest of the remedy in this 1412A10C provision knocked out that as a potential remedy. Instead, had they really wanted to overrule Burlington or control Burlington in that dramatic a way, they would have made it a lot clearer that that's what they were doing. In TA, it was a kid who had actually been denied eligibility and so had never had the occasion to be served in the public school program. And the Supreme Court said that tuition reimbursement was available for that student as well. So it kind of leaves as the upshot that you've got this gloss on the statute as a whole that provides for a tuition reimbursement remedy, as well as the more specific language that we've got quoted that came in the 1997 IDEA amendments. You know, that conceivably could lead to problems, but by and large, it is not. The real problems with the 1997 amendments, as far as I could tell, were simply that the drafters of the statute in their wisdom put that provision of the law in with the other state eligibility for federal payments provisions rather than in the remedies for parents provisions in 1415. But once the bar figured out that all of this was found in 1412, then a lot of the problems that I think had appeared earlier started to disappear. So that being said, then we've got all of those real basics for tuition reimbursement. The Second Circuit, needless to say, has weighed in a bit on this topic. And I've got a quote from the language that seems to appear in almost every Second Circuit reimbursement case. As has been pointed out, one of the things that's a little bit interesting about it is that New York, in its law, makes it quite clear that with regard to all issues in a reimbursement case, except what the Second Circuit gives as parenthesis number 2, establishing that the unilateral placement was appropriate, it's the burden of the school district or Department of Education to both produce and bear the risk of non-persuasion on the issue. So although I guess it's not necessarily the interpretation, but the Second Circuit's language could, I think, probably be read by some to place a burden on the parent with regard to this last provision of the equities favoring the parents. In fact, that would be contrary to what the New York law would require. So that's really basics and what I wanted to try to get out as rapidly as we could at the very beginning. The next thing that we'd like to really get into a bit is the topic simply of, so how it is that you establish that there's been a denial of free appropriate public education. And some of this is for those folks who might have been hiding under a rock for the last, I don't know, year or so. The Andrew case that came down from the Supreme Court last year didn't overrule the Rowley case, which had expounded on appropriate education before that, but it certainly did place a new interpretation on the topic. Whereas Rowley, and this is the way that the Andrew court had looked at it, established what the approach would be for a kid who's in a mainstream setting and is doing well in a mainstream setting. The court said, well, in Andrew, the court said that the Supreme Court hadn't had occasion to try to deal with a child who's not in that situation, and said with regard to that child that the 10th Circuit's approach of requiring something that's merely more than de minimis benefit was not right and really was a misinterpretation of what Rowley had said. And instead, that children were entitled to a markedly more ambitious program than that, with goals that would be challenging for that individual child. And so to that extent, really did create a different approach certainly with regard to what the 10th Circuit had been doing, and I think caused a lot of other courts to re-examine what they'd been doing with respect to appropriate education, or FAPE, in general. I thought to just give you a case or two from the Second Circuit and from New York to see what the local courts had been doing on that topic. And sure enough, the Mr. P case came out this year. Interestingly, said that, well, we, the Second Circuit, think that we've had this right all along, and we did not do what the 10th Circuit did and had merely more than trivial advancement or merely more than de minimis benefit. Really what we were doing was anticipating what came out in Andrew F. Mr. P in itself upheld what the district had done, although much of the debate there really was over whether the kid should have been evaluated and identified earlier, as well as whether the particular services that were offered the kid met the appropriate education standard. I thought I would also put in one case that kind of works in the other direction a little bit, where the parents prevail and where the court says that the services that were offered were not up to an Andrew F standard. That's that AW case that you see in the outline. The interesting thing on this one is that the court took the SRO a bit to task, saying that the SRO's approach to appropriate education in the case was, well, the child had done very well in a small classroom setting. The school district then offered a much larger classroom setting, and the SRO seemed to be reasoning that because the kid had done well in that smaller setting, therefore the kid could do well in a classroom of up to 30, and the court thought that that was not realistic and thought that the Andrew F standard of being a challenging but appropriate individualized program for the child really required something different, and upheld the reimbursement request there. So that's what I would do with regard to simply denial of FAPE. We have actually some questions that relate to that. I should mention, just before we get into that for a moment, that we thought in this presentation to do a little bit more of kind of a question and answer format to try to get into a little more of the details of the way the law operates, rather than simply kind of going over cases the way that we've done in a lot of the other kinds of programs. But let me move on to the next slide for a moment. Deustadi, did you want to cut in here?
Hi. So code number 2 is on your screen right now. Code number 2 is on your screen. Please jot it down and have it on your affirmation form. Code number 2 is on the screen. I have only one question. It's the same question that came in earlier in the at the start. So I'll offer it, but I believe you're going to address it later on. So if you want to defer until later, that's fine too. Are parents who send their child to a private school entitled to receive the cost of related services as well as the cost of tuition, where the private school charges them separately for related services?
And I will try to address that a little later on, but to give a bit of a short answer for it, it depends, I think, on whether the related services are something that's required to provide free appropriate public ed. If the court thinks that, or the hearing officer, you as the hearing officer, think that the particular services that were provided exceeded or more than what actually was needed to provide free appropriate public ed, and the services are segregable, there is support for the proposition that then you can reduce the reimbursement such that those separated, not required services would not be reimbursed, whereas the remainder of the tuition or the remainder of the other services would be. So I hope that answers that, but we'll again try to pick it up a little bit later on as well.
Okay. Code number 2, last chance. Going, gone.
Okay. So as I mentioned, what we'd like to do is try to answer some questions that might come up. And this one is, the first one, kind of the inches, missed by an inch is as good as a mile question. So does a limited deficiency in an IEP justify tuition reimbursement? And to some degree, this is the question that gets answered with respect to the question that was just posed. So yeah, by and large, courts, at least to my reading, both of the New York case law and the case law most everywhere else, asks, has there been a denial of FAPE? Where there's been a denial of FAPE, then a remedy is appropriate, and you then go to the question of, well, what remedy is appropriate, and try to figure it out from there. That being said, however, if what the parent did was more than what actually remedied the particular deficiency, and you can separate it out, there is authority, particularly this LK case out of the Southern District that was remanded and affirmed, although not exactly affirmed on precisely the issue that we're talking about. So I'm not sure that we can view it as a Second Circuit ringing endorsement at this point. But the idea that if you can separate out those services that exceed what's needed to provide FAPE, then you can appropriately reduce the reimbursement. If you really can't do that, and at least the reimbursement amount on the whole is reasonable, it would appear that the converse proposition would be that then you wouldn't be proper reducing the amount. Other question. So, there's been a lot of talk about something that some folks have called a snapshot rule or something else. The idea in general that you evaluate whether an IEP or a placement offer is appropriate as of the time that it's offered. If additional information comes in later that indicates that, well, maybe it really wasn't appropriate, then yeah, that's true, and it might call for a change in the prospective services that the kid gets, but it's not a reason to conclude that tuition reimbursement or some other compensatory remedy is necessarily appropriate, because based on the information that was there that appeared to be adequate at the time, the school district did make an offer of services that was an appropriate offer. And that's a widely accepted view. However, I guess some things probably need to be emphasized a little bit with respect to it. For one thing, you have the RE case in New York. Applying that idea in a somewhat different way from the way it had been developed before, saying that, well, and they didn't use language about snapshot rule here, so I think it's important to keep that clear, but they did use language about retrospective evidence. And they said with regard to that it would be wrong to allow a school district to bring in evidence of services that they would be offering a child as part of the child's program if they did not put those services on the IEP, or at least offer them during the resolution session following the initiation of a due process hearing. The reasoning of the court there was, I think, less the idea that this in some way was looking at the wrong time period. It really, to my mind, seemed to have more to do with exercise of due process rights, that the parent was put in a difficult position if the school said that services that were not being part of the written offer would be offered. The parent didn't know whether to demand the due process hearing to try to make sure that those services actually were offered, or to go along with it, but then not have any real enforceable mechanism if the services then later on were withheld, didn't meet the standards that the school district said that they would. You can put in evidence, obviously, under that approach, even if it's information elaborating on the services or describing the services. There's nothing that the Second Circuit said that would forbid that. But it said that if you've got a service that's not on the IEP or hasn't been offered in the resolution process, then no, you don't bring in evidence on that. Now, whether they should have used the word retrospective evidence, I think that could be debated. It maybe was language that just led to more confusion than it's worth, because you do see sometimes some uncertainty as to just what it means. Nevertheless, this basic idea that the offer is the offer and the parents have got to rely on the offer is, I think, the clearest thing out of RE. What about then the idea of a snapshot rule in general? What is it that you can look to in a tuition reimbursement case with respect to timing, what it is the district knew when, what developments happened afterwards? There, I think you've really got to piece together a number of things to make sense of whatever the rule happens to be. For one thing, the RE case itself said that it would be appropriate to use evidence after the fact, that is what the child does to show or does after the kid's in a unilateral placement, to show that the unilateral placement is appropriate. So if the child does very well, succeeds, learns a lot, after the parents remove the kid from the public school program and put the kid unilaterally into a private school program, RE said, yeah, that's admissible evidence that the program that they chose is appropriate and to that extent eligible for reimbursement. What about if it's being offered not so much for that topic, but rather for the topic, the kid did so well in this unilateral placement, so therefore the public school placement in which he had previously stagnated has to be deemed to be not appropriate public education. And there's where things, I think, get a little bit stickier. You can say, well, in a sense, the kid's progress afterwards doesn't quite capture the question of whether the services were appropriate beforehand, because if the child were given, for lack of a better word, Cadillac services or way beyond what actually would be required under the law in the unilateral placement, that then the success that the kid would have wouldn't show that the services that had been offered previously were bad. It would just show that these services are really, really, really good. Still, you can imagine an inference that, yeah, but if what the parentally chosen placement did just was different or seemed to meet the standard of providing an appropriate service and the kid did really well, maybe that does support the inference. Perhaps it isn't the be-all and end-all of that conclusion, but it still does seem to be relevant evidence, certainly as to what the kid's potential is. And if the services don't appear extraordinary in some fashion, or appear to be those that would be absurdly expensive or something like that, may, one would think, show that the services that had been offered previously would not be appropriate, or so I think could be argued. Is there support for that proposition? Well, interestingly, Andrew F. maybe does support that, because although Chief Justice Roberts didn't make perhaps as big a deal out of it or didn't relate it directly to that topic, Roberts does mention at some length the fact that Andrew had plateaued or stagnated in the public school program that he was offered in Colorado. And then once the parents did pull him and put him in this Firefly Academy, all of a sudden he did extraordinarily well. They developed a behavior intervention plan that identified the most problematic behaviors, set out strategies for addressing them, added heft, in Roberts's words, to Andrew's academic goals. Within months, Andrew's behavior improved significantly, permitting him to make a degree of academic progress that had eluded him in public school. If that's irrelevant, it seems odd that the Supreme Court would have made as big a deal out of it as they did. So I think the implication there is that the evidence is relevant, even if it's not necessarily determinative. But obviously you'd need to make your own judgments exactly on that. What if the kid does badly in the unilateral placement? Does that then mean the unilateral placement is not appropriate? I think, again, it might support that inference, but it wouldn't be conclusive with respect to it. And the CB case that I put in the outline is, I think, an example of that. The court says that, well, he didn't make much progress in the unilateral placement, but it appears to be one that does look appropriate for the child's needs. And after all, the parent couldn't afford what might be a better program for the child. So we think it is appropriate in this instance to allow tuition reimbursement. And I threw in an out-of-area case from Pennsylvania that essentially makes the same kind of point and suggests that you use a prospective approach, really, in both looking at what the school district did and looking at what the parents ultimately wind up buying for the kid.
Mark?
Yes.
This is Lynn. Whenever I think we use how a child did under an IEP as a measure of whether it's good or bad, we tend to think that that's the only thing that's impacting the child's learning.
Yeah.
And I've had cases personally where other factors in the child's life have come into play and have been debated as to a reason why the child did poorly, even though the IEP or the unilateral placement was really a good one. For example, a divorce in the family, a death in the family, a bullying, or the child was ill. You can get into a real quagmire sometimes as to trying to figure out why the child did badly and how that may or may not have impacted the value or the correctness of the IEP.
No, that's a really good point. And, you also have some conditions where the child's abilities deteriorate. That's certainly true with some illnesses, true with Rett syndrome in some cases. So that can be another factor that does have to be taken into account. I think the point that I've heard made often is, yeah, but you still take the child as you find the child. So if the child's needs increase, there should be some ongoing continuing monitoring of the child to make sure that at least the predictable turbulences, if you will, wind up being taken care of.
I just want to jump in here, and I think it's important to just emphasize that in the fact scenario that Lynn mentioned, he obviously had that information in the record, and that information was, I would presume, Lynn, that you made findings of fact specific to those outside influences in order to find either that the unilateral placement was appropriate, despite the kid might not necessarily doing well in it because of these other factors, or vice versa, but that information made it to the record, and you made specific findings of fact to justify whatever conclusion you were making.
Yes, and it's a little bit of an awkward situation when you almost learn by accident, for example, whether there was a divorce in the family or a death in the family or the child was ill. Then as a hearing officer, do you pursue a line of questioning in that regard, or do you discuss it with counsel in terms of whether that line is appropriate? I mean, it's one of those things where do you complete the record so that you have a basis to determine whether it was or was not a contributing factor in the child's lack of progress or whatever? That's a real touch and go thing.
Yeah, no, I've certainly heard parents say that, well, what they're doing is they're trying to blame the lack of progress on us when in fact the services are not being offered that ought to have been offered. So I can imagine it would trigger a certain amount of resentment in some instances.
Oh yeah.
Well, maybe we move on to the next topic if there is no further discussion on that. The next topic is this, so if prong one is appropriate education or lack of appropriate education. So assume for the moment that the parents have prevailed or appear to be prevailing or could prevail on the topic of the whether the placement, whether the program offered is appropriate trying to show that or if the school district fails to show that the program being offered is appropriate. So that's been established. What comes next? Well, under the New York law, it is this one that the unilateral placement is appropriate, which under New York law is the topic on which the parents do have this burden of production and persuasion. And I've given you the cite and a brief excerpt from the statute on that in the outline. The question, as usual, winds up being really one of just how it is you deal with the details here. And I've got just this huge list of cases that seem to bear on this topic of, so just how good a placement does it have to be? How effective must the unilateral placement be? And frankly, you can probably find support for most anything in most any situation. I tried to just pull up a number of representative cases, kind of with a bit of an emphasis on ones that are well known and ones that are a little bit more recent, and sometimes ones that just pick up topics that hadn't been dealt with elsewhere or felt a little bit less run-of-the-mill or a little more out of the ordinary that might be highly relevant here. And I think it probably should be said that you've got more cases from the Second Circuit on this topic than I've seen pretty much from other circuits. Other circuits, it seems that you'll find the court placing much more emphasis on the first question of whether the program offered is appropriate, and often not paying quite as much attention to this topic of whether the unilateral placement is in fact appropriate for the kid's needs. The Galliardo case is probably the single best known case on this, and it's the one where the child actually was placed at a Quaker school by the parents, and the kid did quite well after having some problems in the public school setting that had previously been providing the services. It is true that the school did have very small class sizes, and probably most importantly for the kid to flourish, had very effective policies against bullying that enabled the child, I think, to be more comfortable, to manage to succeed both academically and socially in a way that might not have been the case otherwise. But the Second Circuit's view was that, and this was really affirming what the IHO had done, was that, yeah, but for the child's special education needs, they were essentially psychological in nature, and you needed some kind of a therapeutic setting to address those needs. And so for that reason, it really wasn't appropriate in the sense that IDEA was looking for a placement to be appropriate. And they thought that simply the fact of the academic or the social success wasn't enough for that. Now, that may actually contrast with some of the other cases that appear to go somewhat in the other direction. I think the Shore Regional High School case against PS that then Judge Alito decided in the Third Circuit seems to go a bit in the other direction. But it's worthwhile noting that the Second Circuit, at least in this quite prominent case, did emphasize this idea of the particular therapeutic needs of the kid that it said the placement did not actually address. And more recently, the Doe against East Lyme case may actually fit in that category as well. This is the one where the parent placed the child in a school called Solomon School. But again, it was more that the kids seemed to benefit from the fact that it was small class sizes, a lot of individual attention, and the court at least didn't think that it was special education services that were being offered to the kid that were critical here. In fact, there were related services that the parent provided and that ultimately the court said should have been funded, although under what appeared to be more of a maintenance of placement or a stay put rationale than anything else. And the court did make the interesting point that, you know, if you take a lot of kids without disabilities and put them into a small class size environment where they get a lot of individual attention, sure, they'll do better than they do in a large class size where they're one of a bunch of kids kind of fading into the woodwork. And the court thought that the particular placement here was not something that was tailored enough to the child's special education needs to fit under the reimbursement umbrella. As I do mention in the outline, though, the court did offer or did require that there be various related services be reimbursed, but it really was under the stay put rationale rather than anything else. Got a few other cases that go in one direction or the other. So that Hardison case is another Second Circuit case. The SRO said, well, you know, we're not quite so sure whether the services were great or they weren't great for the kid in the unilateral placement, but since the parent really does have the burden here and I can't make up my mind on it, the parent loses. So it does show the premium of making sure, if someone is representing the parent, to make sure that there is adequate information in the record by which the IHO or SRO can make the finding that the unilateral placement is appropriate. Other cases kind of go in the same direction or otherwise say that, well, there are good reasons we think why the placement chosen was not appropriate. In one, that LH case, it's not a New York case, but it does say that the Montessori program, which again gave a lot of individual attention, but wasn't in any way conventionally a special ed program, and one that appeared not to be designed specifically for the kids' needs, would not be reimbursed under the rubric that they used. Other cases that kind of go in the other direction, I do fear that sometimes in our presentations we have well, here's cases if you want to go one way, here's cases if you want to go the other way. But I think you probably can figure out distinctions in the cases that make the law here a little more coherent than it might otherwise seem. The Frank G case is one where the court thought that the services that were being offered were appropriate and the unilateral placement had to be supported, even though once again it really wasn't a special education school by any means. It really was a parochial school, but they did adapt the program sufficiently that the court was comfortable saying, yeah, it met the free appropriate public education test because of the individualized services that were offered. So it had a lot of one-on-one assistance for the kid. The kid had a lot of difficulties with communication, and they created kind of a set of books for the child to be able to communicate more effectively, set the kid apart for seat work so that there wouldn't be distractions. All of these were really viewed as essentially special education interventions, even though they kind of didn't get that name when they were being offered. And interestingly, the court there did rely quite heavily on the fact of the kid making a lot of progress in the setting. So I guess that's additional support from the Second Circuit on that proposition. And there are other cases that kind of go in the same direction. The Wappinger's case, MN, which got a little bit of notice, I think, among various folks in New York after it came down last fall, said that, yeah, although the services that were provided by the unilateral placement were not perhaps optimal for the kid, there was, and they emphasized this a lot, the fact that the unilateral placement was willing to keep changing the program to try out different things to have the kid make progress. seemed to impress the court. And that you may find that as a hearing officer that impresses you as well. The idea that if you've got a unilateral placement that maybe couldn't figure out what to do at the beginning, but ultimately adapts such that the program that they offer does wind up being responsive, that could be a consideration that you would want to pay close attention to. I thought I would throw in, they're after a while, if you look at the New York cases, you see cases dealing with specific schools that go usually in different directions. So Kildonan is one that seems to come up in a bunch of cases. That AW case is one that says Kildonan is appropriate. You can imagine for another child, conceivably, you could find decisions saying that Kildonan might not be appropriate. It really does depend upon what the child's condition is, as well as just what it is the unilateral placement offers for that particular child. There's a Second Circuit case, the CL case, that deals with a case called a school called Eagle Hill. And although I'm not sure, I could swear that I've seen that school mentioned more than once in the case law as well. And whether it's uniform that every placement there has wound up getting reimbursed, I don't know. But again, I would be not at all surprised if you'd be able to find cases that could go in more than one direction with regard to that placement as well. It really does depend upon the kid. It depends upon the program, and it I think, as Lynn was suggesting a moment ago, really does depend upon the state of the record and what it is the parent brings in on this topic, what it is the school district responds with. The couple of cases that I threw in again, and it's more or less just to reinforce the point that I was trying to make a moment ago. The fact that the kid doesn't succeed, I think, doesn't necessarily mean that the unilateral placement is inappropriate. And if you kind of undo all of the double and triple negatives there, the point is simply that, yeah, sometimes it just doesn't work, even though it appears that what the parent chose was a good choice based on what the parent knew at the time the unilateral placement was being made. So that is kind of covering a lot of case law in a fairly compact way, but what I'm trying to simply get across is that it ultimately winds up being an issue of fact and one that has to be resolved based on the state of the record and how it is you're going to approach the nature of the private program that's brought in and the kid's needs. Other things that kind of fit in with that category or that might also relate to that. Well, one thing that's come up, and I've had really inquiries on this from a number of folks in a number of different settings. So what if the parent didn't initiate a unilateral placement, but the parent did initiate unilateral related services? I guess the most obvious one would be where the parent keeps the kid in a public school, doesn't alter in any way what the kid's being offered, except to the extent of adding services after school, like tutoring or like speech therapy or assistive technology services or something like that. Obviously, the 1997 language doesn't specifically address that, and Burlington and Carter, for their part, really don't quite specifically address it either. They're still talking about a unilateral placement or a removal of the kid from the public school setting. Well, what if the kid hasn't been removed from the public school setting, but instead is kept in the public school setting and is simply given additional related services? Can those related services then be reimbursed? The answer to that, as far as I can tell, is yes. Although it's always has struck me that there is less in the way of reported opinions on that topic than you might expect that there would be. The Doe against East Lyme case, I think by implication, certainly suggests that even if you don't put the kid in a different placement, that related services are still subject to be reimbursed. It's true in that case, the parent did put the kid in a unilateral placement, but of course the court there said, yeah, the unilateral placement wasn't appropriate, so you don't get reimbursement for that. And it was only under the stay put rubric that the related services that got purchased outside got reimbursed, but nevertheless, they did get reimbursed. So I think the implication is that related services standing alone would be subject to reimbursement. And after all, you know, if the Forest Grove case is saying that the 1997 codification is not the only basis for reimbursement, the idea that there'd be a reimbursement remedy for related services that would stand independent of both the 1997 revision of the statute and arguably independent of Burlington, or really only being able to use Burlington as an analogy, I think would support that as well. The Still against De Bono case is, I think, probably as good as I could find at the circuit court level from the Second Circuit of supporting related services as a kind of standalone item with respect to tuition reimbursement or with respect to reimbursement remedies. So I think it can be used for that. Yes, please.
What if ABA, a lot of parents are upset with a program not offering any ABA or sufficient ABA, or maybe it's in the reading area with Linda Mood Bell, or in the dyslexic area with Orton Gillingham not being offered. Do you think there's any authority for a parent getting those services, even though they're not technically probably related services as we would define them under IDEA, for getting those outside privately and then seeking reimbursement, contending that the district services in that regard are deficient or just basically the wrong methodology?
Yeah, that's a really interesting question. I'm not sure I've got an entirely straight answer to it. I mean, I could see where the parent might have some incentive not to refer to them as related services and instead to think of them in some respect as tuition, simply because you've got so much more case law that refers to tuition and much less that refers directly to related services. But, you know, I know, as a matter of fact, Lynn, that you go back with regard to special ed for quite a long time. And I'm sure you remember back in the 70s and 80s, there had been kind of a long debate at the Department of Education level as to what's a related service and what's special education. And in particular, it seemed from what I could divine out of all of that, that what the federal regulators wanted to do was enable states, at least with some range of services, to call them either related services or special education, or maybe something completely independent of that. So you had some states like, I think Wisconsin was in this category, where speech therapy was being offered independently of IEPs or any kind of designation of the kid as being eligible for special ed. And it seemed the federal regulators wanted to enable the state, if they so chose, to keep doing that. And then they could just call that a related service. The kid then only needing a related service would not be eligible for special education, because to be eligible for special education, you had to be in need of special education and related services. So it became rather an arid topic as to whether something was a related service, special education, both, or it depended on the context or depended upon the state. But that being said, I think the key thing is that if it's part of what the kid needs, that you could make a pretty persuasive claim for reimbursement. What's your take on that? Do you have a different view?
No, I mean, when I go back to the IDEA definition, related services, something that's necessary to allow the child to benefit from special ed, I mean, I think you could make an argument that the reading or the ABA or whatever would kind of fit into that category. And of course, related services is not exhaustive in terms of what they say in there. We've had some pretty crazy things, in my view, denominated as related services. So I do not know of any case. I'm surprised that one hasn't come up, but I just offered it because I think it's something that we could reasonably anticipate will come down the road.
There
Yeah,
is.
I mean, oh, go ahead, please.
There is a recent Third Circuit unpublished decision from 2018 in which the Third Circuit decided that the parents were entitled to reimbursement for out-of-pocket expenses for services that were listed in the IEP, but the private school did not offer to the student, and the parent therefore supplemented the private school with these, and there were related services, supplemented the private school. And the Third Circuit said that's okay. Not only does the parent entitled to the reimbursement for the tuition, but also for these out-of-pocket expenses, because this, and I think the fine print here was that there wasn't a dispute that these services, the student needed these services because they were listed in the IEP. Overall, the program was not appropriate for the kid, but these related services were listed in the IEP. The parent did not dispute that the kid did not need them, and the school district agreed they needed them, and the Third Circuit said, yes, parent, you can seek both the tuition reimbursement as well as the out-of-pocket expenses for these related services.
So, Diostati, is that the Kirsch case? Because that's part of it. Yeah. So that is in the outline on page 13 if anybody did want to dig it up. Although I'm not citing it for that proposition and frankly didn't remember that that's what they had done. So I guess the only other thing that I wanted to add with respect to what Lynn had said, there is case law going back way back when, the Polk case out of the Third Circuit from I think 1981. Or no, it's after Rowley, so it's a little bit later than that, maybe 1983 or 1985. Says that if you've got a kid with really, really severe needs, a lot of what we think of as the child's educational program will wind up being things that might in other contexts be viewed as related services, like physical therapy or occupational therapy. That might be the bulk of the kid's school day. And I think that's probably still true. Again, suggesting that there is a certain amount of fluidity between what's special ed and what's related services. I did want to make sure that we kind of had marshaled in one spot this question of, does the unilateral placement actually have to provide something called special education? And in a way, you could maybe view the Galliardo case as saying that, but I'm not sure, because the Frank G case, which we'd also kind of listed there, seems to really go in the opposite direction. It seemed to say it isn't whether you call it special ed services, it's whether it's sufficiently individualized for the kid's special ed needs that makes it critical, makes the critical determination. So I guess the short answer I would give is no, the unilateral placement need not provide, quote, special education, but with a rather large proviso if the services are sufficiently tailored, if the services are sufficiently specialized for the special education needs that the kid has. And I looked around for some additional cases that maybe would work in that direction, and sure enough discovered that the topic is maybe a little more subtle than I was kind of letting it on as being. So the RB case that you see listed in the outline, yeah, it does provide for reimbursement for what is effectively a supplemental program, kind of what might look like what Lynn was hypothesizing with the after school or brought in to regular school type services, but interestingly limited the reimbursement to those additional services being brought in. So did not allow for reimbursement of the the general ed program that the kid was getting in what was, I think, actually a parochial, although I'm not sure I'm remembering this correctly, a private school. And Weaver then is kind of the flip side of that. So the parent did place the kid in a special education school, as denominated as such, but the court felt quite strongly that the services that were provided were not what the kid needed, that it wasn't tailored to the kid's needs. They had a special education program, but it was the wrong program. And if that's the case, then once again, you could argue that, yeah, but that's not appropriate education for this child. The parent hasn't met the standard with regard to appropriate ed being provided in the private placement. I did want at this point as well, though, to make sure that I mentioned that Shore regional case, because I don't kind of want it to get forgotten, in part because it is Alito, who then goes on to much greater things, of course, later on. But also, it raises an interesting question. So you had the kid who's being relentlessly bullied in a public school setting. Parent is able, as sometimes is the case, to place the child in a public school program. I don't know if it was in the suburb next door, but at any rate, someplace near enough that the kid could get to, pays out of district tuition, which again is something that you can't always guarantee you can do, but if a school has excess capacity, sometimes you can. And the kid is not at least designated as being special ed eligible, but is given additional assistance to the point of actually being put in a class that was denominated as special ed for math, but mostly was simply in an environment where there was a rigorously enforced anti-bullying policy. And that's what seems to be the single most important consideration in the kid doing well after the kid is removed from the public school setting. And it is true, you've got cases like TD in the Second Circuit saying that an environment with pervasive bullying is not an appropriate setting for a child who is special education eligible, and it undermines whatever progress the child would be able otherwise to make. And so in a way, arguably what the court was doing here was kind of anticipating TD's approach to bullying and allowing for reimbursement in, a program that was tailored, it's true, for the kid's needs, but was predominantly a general education program with protections for the kid, but protections that apply generally to everybody against bullying, and that wound up being the appropriate placement for which tuition reimbursement was provided. So I think it's a significant case, not only because of the author, but because it does, I think, say something quite important about bullying, something quite important about really what winds up then being appropriate education for a kid who has kind of a target on his or her back with respect to abuse by other students. And I've got a couple of other cases, at least one other case, that MG case, where the general education placement was found to be proper because it did have small classes which the kid needed, did have a quiet environment which the kid needed, and the court felt that that was adequate to do the trick. Although I should mention that that's not a Second Circuit or a New York case, it's a DC case. Deustati, back to you for a sec.
No, it's not going to be for a second. We have a lot of questions and comments.
Oh, okay.
But code number 3 is on your screen. Code number 3 is on your screen. So I'm going to leave it up there to be there for a few minutes. But make sure you put it down on your affirmation form. And I'm going to start from the beginning, understanding that some of this was much earlier in our conversation because we covered so many cases. Regarding nuances with reimbursement, how about a kid gets put into a unilateral placement out west and the parents are looking for not only placement and tuition, plus all costs for services required there, fees, including room and board, but also the boy's transportation there and back, plus transportation for his parents there and back, together with rental car and hotel costs. And I'll add, and in between, also pay for my mortgage.
Interestingly, one of the hearing officers, I think, actually posed this question before the program, and so I searched around to try to find some support on it, and sure enough, didn't find anything from New York or the Second Circuit, although that doesn't mean it isn't out there. It just means that I didn't locate it when I was trying to look for it. But there are cases that do provide for things like parental reimbursement of travel expenses. One that I did find is one called David P. against Lower Merion, Merion School District. It's at 29 IDELR 23, Eastern District of Pennsylvania, 1998. If you have access to Westlaw, it's 1998 Westlaw 720819. But it's not alone. I mean, there are other cases that do that. Now, obviously, at some point, you do get into what Justice O'Connor was talking about at the end of Carter about that this is not a reasonable expense, or it's an excessive expense given the needs of the hour. But it is true that if you've got to get the kid there, that is a cost of the operation. It is true as well that if the school district had placed the child in a residential setting, there is that regulation, and I think it would also be the implication of the statute as a whole, that all expenses, including tuition and room and board and all that, do wind up being provided as a matter of free, appropriate public education.
This is where making a record is critical in terms of, and you've got to say when you start doing this, I think, to the parties, I haven't decided yet prong 1 or prong 2 or anything, but now's my chance to have a record in the event I do. And so that's why I'm asking these questions. But some of the programs, in addition to just getting the child out to the school and the parents' transportation costs, I can recall of having these issues in front of me, and I agree with Mark. There are cases out there, they're usually old ones, but there are cases out there that say you've got to get the child there, and depending upon the age of the child or the child's particular needs, you may have to have a parent or someone go with the child, and it may be a distance where you've got to engage in air flight costs and hotel and meals. And some of these programs for the more emotionally involved kids will also have as a component of that program that the parent come out and participate in certain things in the program on occasion. And then you've got the child maybe coming home over the holiday break at the end of the calendar year. So there's a lot of things that you will want to inquire about on the record in order to have a basis factually to decide what is and is not reasonable, what is and is not required for the program to be reasonably effective if the child is found to, if the program is found to be, quote, proper or appropriate.
In terms of parallel references, it had been, and you guys out there in cyberspace can send me a note if it has changed, but it had been that New York statute had provisions in there that if the kid was placed in a residential placement, for example, and needed to travel, that not only did they cover the cost of the round trip at the end and at the beginning and at the end of the school year, but also up to, I think, 4 additional trips. Obviously, it may probably come in for the holidays. So if that's still out there, that's a parallel reference that you may want to borrow from to think about reimbursement for those costs if it comes up. Also, in the context of IEEs, correct me if I'm wrong, Mark, but there are cases out there that speak to if the parent has to travel to obtain an IE, that the costs of that travel would be part of the IE. So those, again, parallel references.
No, that's right, and that's also a worthwhile point, because reimbursement of IEEs is another topic that comes up really frequently, and you do find a lot of case law saying what really matters is what's reasonable and what's not.
So I'm going to continue. This is a comment, and this is from earlier in the discussion. I had a case where a child did about the same in the unilateral placement as he did in the public school. My conclusion, either both were inappropriate or, as I found, both were appropriate given the child's functioning. So FAPE was provided. Unilateral placement showed that. Interesting approach, right? The unilateral placement approved your case in favor of the school district. The next is a question. Is it appropriate to inquire with the parent as to how they assisted or frustrated the success of the IEP at home? For example, completing assignments, following up with school suggestions for behavior. This question came in around the discussion regarding divorce or and all that.
Gosh, that's a toughie. Well, Lynn, do you want to try to take that one while I try to figure out the answer?
I think it very well may be, but it's very risky territory because the district may be trying to accuse the parent of the child's shortcomings. And one of the areas, particularly with behaviors, is a lot of behavioralists will say that a good behavior intervention plan should cover the child's behaviors at home as well as at school, and that the parent, as staff, ought to be trained on how to implement it. So if you get into this area and they're taking a shot at the parent with respect to they didn't do anything at home or maybe did some negative things at home allegedly, another inquiry could be, what was the nature of the behavior intervention plan, and was it meant to be, or was it considered to be addressed, implemented in the home, and were the parents trained? That gets into a whole area that is obviously very emotional because it starts to get into the parents' own kitchen, so to speak, with regard to their home situation.
And I guess the reaction I have on it maybe is a little bit influenced by my perspective as representing kids and parents. I mean, it does strike me that even a kid with an incompetent or not terribly with it parent is still entitled to appropriate education, and it could be that. Yeah, that then means that your expectations do have to be somewhat different, because if the parent is not assisting or is in some way creating some difficulties, you're not going to be able to achieve the progress that you'd like to be able to make. But you do still take the kid as you find the kid. And the point is that if there are mechanisms by which the intervention can be adapted to account for or to work around the fact that the parent is not going to be all that helpful, then I think the kid's entitled to that if that's what appropriate education for the kid is. But maybe I should caveat that that's my opinion. I'm not sure that everyone would agree.
Well, parent training and counseling is in fact a related service. You rarely see it, but it is a related service.
And one's spelled out in the New York law. Yeah.
A comment about divorce, illness, etc. Parents don't resist. To the contrary, they often bring in outside difficulties precisely because it lends support to the child needing more services. Mm-hmm. Another comment, if related services are insufficient, then there is no FAPE. So the hearing officer gets to fashion the remedy. There's no case law because there's little incentive for districts to appeal.
Oh, good point. Yeah.
Another comment, New York is a related service only state. And that's, yes, and that's in its statute. Could related services be considered a needed reasonable accommodation under Section 504 of the Rehabilitation Act?
I think the answer to that has got to be yes. Particularly things that are spelled out in the ADA regs, like communications with service technology services and the like, could also be deemed 504 accommodations.
Okay. I believe this was a thought while right after you said something, but no court I'm aware of has ever determined that bullying in and of itself constituted a basis for eligibility for special education.
That's interesting. Yeah, I think that probably is right. So what TD instead says is that that bullying can make the placement not appropriate. which is, I think, a somewhat different point. On the other hand, yeah, I guess you could imagine that if the kid does have a condition that meets the definition of disability under IDEA and is in need of special education, you might effectively be able to kind of bypass that question. I'm not sure. I guess it depends a little bit on what the commenter is emphasizing.
And then finally, clarifying prior comment, education law 4401 includes related service in the definition of special education.
Mm-hmm.
And
cool.
one last comment, if the DOE does not want to pay for travel, hotel, etc., the DOE must provide, find an appropriate program close by.
Okay, answers that question.
All right.
And that may also help explain Lynn's point that you don't seem to see quite as many cases anymore. I mean, it could be that the school districts have just developed more local or in-house programs than they had, 10 or 15 years ago.
All right, you can continue.
Okay, let's move on to the next slide, which is slide 13. So, question, what about the placement being restrictive? If part of the idea is that the placement that the kid should have is one that's the least restrictive setting, could the parentally chosen unilateral placement not be appropriate because it doesn't provide adequate interchange or adequate exposure to kids without disabilities? We're assuming for the moment that the prong one has been met here, that whatever it is the school district is offering is not appropriate. Would it be a reason not to reimburse that the placement that the parents chose is more restrictive than it needs to be? The short answer appears in general to be no, simply because courts have recognized that parents really have very, very little control over that topic. That if they're trying to get services for the kid, they can't, unlike what the parent was able to do in Shore, kind of go to the neighboring public school and say, put this kid into a mainstream setting with better or different or more effective services than my home district is doing. Instead, they wind up going to the therapeutic day school or to the other private school that offers really only a special education menu. And the CL case is the key one in the Second Circuit that says that from 2014. There are cases, though, that go back a lot further. The one that I think of as the grandparent of those cases is the Cleveland Heights, University Heights case out of the Sixth Circuit, which essentially says the same thing that then gets picked up in the CL against Scarsdale case, that parents whose kids are denied appropriate ed have to turn to a specialized school because that's what's out there, and they're necessarily restrictive, and it's unlikely that you're going to have certainly optimal levels of exposure or of integration with kids without disabilities that you might want to have, and otherwise you're just undermining the right to tuition reimbursement altogether. But again, that being said, there are courts that have limited or denied reimbursement because the private placement is way more restrictive than it needs to be. And so I've thrown in a few cases that do that as well. Whether they can fully be reconciled with cases like CL, I'm not absolutely sure. I mean, I bet you can probably find enough factual distinctions that you can thread away among them. But it could be that you also have some differences simply of attitudes of different courts with regard to the topic and how much they're kind of willing to see the parent as being in a dilemma that the parent can't get out of. So the MS case from 2000 out of the Second Circuit does say that the requirement of appropriate ed being in mainstream setting to the extent possible still should be a consideration that would bear on the choice of the alternative placement and may be considered by the hearing officer in determining whether the placement was appropriate. And the abrogation on other grounds, that really is quite irrelevant. Other grounds, it had to do with a burden of proof issue. Really, the other cases I think are going to fit pretty much in the same category. I've got some somewhat further explanations in the outline materials, but I don't think we need to get more deeply into them than we've gotten already. A question that I have always thought was a real interesting one is, so the parent loses on the appropriate education with respect to the unilateral placement. So it's a Galliardo or a Doe against East Lyme case where the court is saying, no, the unilateral placement is not appropriate for the kid. Can the parent then, kind of as a fallback, say, okay, I know we're not going to get the tuition reimbursement, but it is still true that the child didn't receive appropriate education when the kid was in public school. And as you say, the kid didn't get appropriate education once I put him in the private school. What we want is compensatory education to make up for that loss, not only in the period before we removed the kid, but also for that period in which the child was not served appropriately, because we thought we were serving him appropriately, but it turns out, I guess, that we were wrong. It does seem that there is some authority supporting the idea that you do get compensatory education under those circumstances. The Doe against East Lyme case does say that, but really with respect to a stay put situation. So I don't know how persuasive it is with regard to a non-stay put violation, but rather only a situation where you've got inappropriate services being offered by the school district. Parent has also chosen inappropriate services. But for what it's worth, Doe did say that when an educational agency has violated stay put, compensatory education may and generally should be awarded to make up for any appreciable difference between the full value of stay put services owed and the reimbursable services the parent actually obtained. And they said in this case, the board owed reimbursement in the amount the parent expended for services plus compensatory ed to fill the gap of required services that were not funded. And I was looking around for other cases that seemed to do roughly the same thing. There's that HL case out of New Jersey. That was one, but it isn't precisely that the placement chosen by the parents was inappropriate, but that they didn't get tuition reimbursement because of a notice violation under the 1412A10C provision. So tuition reimbursement gets denied because of that, and the parent asks for compensatory ed. And the court there says, yeah, compensatory ed is appropriate in that situation. It's making up for the loss, albeit not with provision of cash for the reimbursement, but rather with regard to something special for the kid. There are cases, though, that go in the other direction, and the question, I guess, is on what ground or in kind of what application will they have to a case that might wind up in front of you as a hearing officer. So the Mr. I case is kind of an unusual one. A very high functioning child with an autism condition does terribly in that doesn't do terribly, but does badly, according to the parent anyway, in public school, is removed. The First Circuit is of the view that the child should have been found eligible for special ed, should have been given appropriate services, but also is of the view that the services that were provided did not meet the child's educational needs, and so the unilateral placement was not appropriate. Parent does, as a fallback, then say, so offer us compensatory education. And the First Circuit said, well, no, we don't think so. We think that if you simply meet the child's needs now, that will in some way take into account whatever deficiencies in the program in the past. And so compensatory education as such is not appropriate. I try to contrast that with some of the mostly more recent, although I think you can find older cases on this as well, case law saying that when you're talking compensatory education, you are talking about something more than what simply constitutes ongoing appropriate education for the child. That it's true that appropriate education that is ongoing for the child will try to remediate whatever deficiencies or weaknesses might not have been remediated in the past. But kind of going back to the Cadillac versus serviceable Chevrolet analogy that we've seen in plenty of cases dealing with appropriate education, it might not be that as a matter of compensatory ed you get the Cadillac, but you get something more than the serviceable Chevrolet, that it really does have to be remedial. And the booze case, which I think I've cited and I guess not quoted, but it certainly does make the point. And there's plenty of other DC circuit case law, although I haven't found too much recent from other circuits on this, does make that point rather strongly. That, yeah, if it's compensatory education, it really does have to be compensatory. And so you can't simply say, well, provide appropriate ed in the future and that'll make up for whatever deficiencies might have occurred in the past. On to prong 3. Prong 3 is the last of our 3 prongs. Lynn, when we were talking about this program conceptually, said that he actually thought that this was the most challenging issue in many respects, and the one that, as a hearing officer, you'd want to make sure that you give a lot of thought to. What guidance do you have out there? Well, interestingly, really what the codification, the 1412A10C stuff says is really simply the notice requirements and the idea that that if the parent behaves unreasonably, that can be a basis for denial or reduction of the tuition reimbursement. And then you've got the line from Justice O'Connor and Carter about the idea that if the services are of excessive cost, that can be, again, another reason that you would not give full reimbursement. But it doesn't, I think, quite fill out the idea of just what is meant by the equities, or what the Second Circuit in particular has in mind as to what the equities demand. And if you look at the case law on it, it really maybe is a little less clear than maybe it ought to be, even if you look at the Second Circuit and New York case law that is under that general heading. So in the classic way of approaching this, the way every lawyer approaches it, what you do is kind of go from the specific to the more general, because often you can find a more specific answer when you can't find as good of a general answer. So the real question, I guess, that is kind of the first one is, so under the notice provision that you've got in 1412, what kind of notice do you really need? And when does it have to be given? When does it have to be given is really pretty much laid out in the statute, that you've got this requirement that it be done at the IEP meeting before removal or 10 days before removal. The provisions that I guess have probably become pretty familiar to everyone that are under subhead triple I or triple small I, and then Roman numeral 1, double A, double B, and Roman numeral 2 that wind up being part of the law that's appropriate here. And of course, at the same time that you've got those requirements, you then also have various exceptions that are built in under subparagraph small Roman numeral IV or 4. So you've got all of that kind of working in one spot to try to give you some guidance. And maybe it is adequate guidance as to what it is you'd want to try to come up with here. So if you look on slide 16, you've got the question of what notice the parents must provide. And what the AW court said, this is a quite recent Southern District of New York case, is that, well, they've got to inform the IEP team that they're rejecting the placement proposed by the public agency, and they do have to state their concerns and their intent to enroll. But, that's really just what's in the statute. So it might not give a whole lot more guidance. The AW court said, well, at the IEP meeting, they were critical of what the district had offered. They did say that they intended to remove the kid. Looks good enough. Seems to fit into the category of what it is the statute seems to want. Perhaps more, I don't know, maybe a little more wide-reaching or a little broader in its implications. You do have some cases that give excuses or create exceptions when, or exceptions for not offering the notice that's required under the statute. In particular, there are some cases, mostly out of DC, where it seems the school district there was in such disarray that they just didn't offer services for kids. They either didn't have IEPs in place, or the IEPs didn't have any kind of a placement offer attached to them. And the parent, and you're kind of reading between the lines, the parent is going frantic, trying to figure out what to do at the beginning of the school year, and winds up enrolling the kid in a private school, doesn't comply with the notice provisions that are in the statute. And the DC courts say, well, yeah, but in a way, the notice provisions really don't apply because they're not disagreeing with what's being offered, because nothing's being offered for the kid. And that would be an instance where the MG case would be illustrative, where there's no placement out there, and so the parent finds one, pays the tuition, or at least puts a down payment on the tuition, and then the court ultimately says tuition reimbursement is appropriate under those circumstances, irrespective of an absence of notice. The letter to Miller, I thought I would throw that in here as well, because it seems that sometimes the courts seem a little bit unsure when the 10-day rule starts to kick in, or more appropriately, I guess, when it winds up lapsing. I mean, does it have to do with when the tuition is paid or when the contract is signed? The letter to Miller seems to say that it's actually when the removal is effected that is the time that the 10-day deadline becomes applied to. So as they say, removal and not enrollment establishes the regulatory benchmark when determining compliance with the parental notice provision. But there, nevertheless, even though there's cases like MG or the like that either don't require notice or seem to require something that's not all that specific with regard to notice, there are other cases that really do go in the other direction and say that, well, the parent mentioned the idea that they were thinking of private placement, but that's not good enough to constitute a notice of intent. Or the parent seemed unhappy, but that isn't enough to fulfill the idea of the what their concerns are with respect to the program that is being offered. And I think you can find plenty of cases that go in that direction as well. The next question, I think, is maybe a little more specific, and it relates a little bit to certainly the MG case and others that we've talked about, but I was trying to address it maybe a slightly more specific level. So does the failure to provide the 10-day notice necessarily bar tuition reimbursement? And the key answer to that, and I guess the most specific one, is, well, no, it doesn't. For one thing, because it says may, and it says may reduce or deny. So that seems to then confer a lot of discretion on you as the hearing officer to see whether you may do it or not, and whether what you want to do is reduce as opposed to deny. And if you're reducing, how much it is you want to reduce, whether it should be just a token amount or whether it should be a significant amount, and what considerations you'd want to look to figure that out. The Board of Ed against MN case is, again, a case just from last fall, emphasizing that, yeah, it is, in fact, discretionary. That here where the SRO said you get reimbursement even though there had been some problems with the provision of notice, that full tuition reimbursement could still be appropriate. Yeah, but what is it that you want to do then? Well, the New Jersey case that I've got cited next, the HL case says, and this I guess kind of reinforces what Lynn has been saying all along, you do want to make really clear why it is that you're either denying the tuition in toto, reducing it, or making no reductions at all, and give specific reasons, ideally supported in some respect in the record, as to why it is you're doing it. So that, I think, maybe once again emphasizes that doing it's a lot of work, that you can't just kind of rely on well, they didn't meet the notice requirement, therefore they don't get tuition reimbursement. Instead, the reasoning ought to be explained. And I've got a few other courts where there have been partial reductions, and I think probably it's safe to say that there are some differences simply in attitude between the courts as to whether they thought that the conduct of the parent was or was not reasonable, or at least somewhat reasonable, in failing to give notice. But also, they appeared to look to whether there was any prejudice to the school district in the failure to give timely notice. And I could imagine that if you could really show prejudice to the school district, that they were willing to negotiate to come up with some other special program, and because the kid got removed, they didn't have the opportunity to do that. Had they had the 10 days, they might have been able to strike a compromise. I think that's a lot different a case than one where there's intransigence, perhaps on both sides, and where the parent doesn't comply, at least in a timely enough fashion, with the notice provision, but where it really appears that it wouldn't have made any difference to what the school district would have done one way or the other. Can the failure on the part of the school district mean that then the parent doesn't have to give notice? Well, the statute does, of course, allow for that. So the failure to provide the parents a copy could do that. Failure to provide the parents a chance to inquire about the school district. The statute doesn't quite say that, but there is New York case law suggesting that that too can be a reason for late notice. And you can imagine, I think, that that could fit in, that especially where you've got the situation like in New York, or New York City, where it seems that the school, that the Department of Ed, New York Department of Ed, offers an IEP, then says, well, you parent, go ahead and look at school 1 or school 1 and 2. They would be the ones in which would be implementing this. The parent doesn't realize until quite late, because they can't get into the school that they were referred to, that it's not going to be suitable for the kid, that might be a reason that late notice would be provided, and the 10 days not complied with. And I think the CU case is a good example of that. Whether that is more than just a rare occurrence, I certainly don't have any information, but I can imagine that parents could be arguing that in such a situation, or where you have in that DC case where there simply isn't any placement out there, and the parents kind of beside themselves and doesn't know what else to do. No, doesn't give notice because all that they had to do was immediately place the kid in that in the private school, and they didn't perceive any other option. There's also, of course, that provision that's in the statute. Oops, wait a minute. Deus Dedi, do you want to come in here?
I do. Code number 4 is on the screen. Code number 4 is on the screen. I have a couple of comments and questions. Do we have time to take them?
Oh yeah, by all means. Could you lean forward a little bit into the microphone? I'm having a little trouble hearing you.
Yeah. Can you hear me fine?
Yes, now I can.
Okay. Sorry about that. The first is a comment. They're just, in my view, the equities are not really a co-equal prong. They're just a way of saying that the remedy we are crafting is entirely an inquiry into and balancing of the equities. The best discussion of this at length that I recall is the First Circuit decision in Burlington.
You know, I think there's support for that in TA as well. You know, because it's a specially crafted judicial remedy. So I think there probably is some good thought behind that.
But I think a good point here is whatever the balancing factors are, you've got to have something in the record to base that balance on, or at least identify the factors.
Yeah.
Another hearing officer said, I don't recall the citation, but there's a case I've cited that says if the district doesn't provide FAPE, it is not in a position to argue against the parent on equities. This always seems eminently fair to me. And the case, I believe, is NR versus the Department of Education, which is the 2009 case with a CV number of 07 CV 9648, or 2009 U.S. District Lexus 27273.
It's helpful.
Okay, give me 1 minute.
Let me comment on that. I don't think that logically or legally follows, because the district could have denied the child FAPE, and yet the parent in their conduct could have been so unreasonable that it at least ought to be a factor in developing the equitable remedy. I'm just not sure that they're.
And that's the question the next question. How about finding that the parents had planned to enroll in private placement, but were going along with system to get district to pay, which I believe what this hearing officer is suggesting is exactly your scenario, which is, what if the parent created the denial?
And I think you can find support kind of in both directions on that. On the one hand, if the parent has a well-considered viewpoint and doesn't budge from it because it's well considered, that's one thing. If they've got a viewpoint where even though something appropriate is being offered, they're still not picking up on it, that's something quite different. By the way, I did find an IDELR site for that NR case. It's 52 IDELR 92. So if you've got access to that, but not to Lexis, you might want to find it.
What is it again? 52?
52 IDELR 92 from 2009.
52 and 92, folks. 52 and 92. I have a case where parents sought to remove student from a public school for many years, eventually secured a place in private school, and paid a deposit immediately. Thereafter, parent requested an IP meeting and disagreed with the IP created at that meeting. Post decision to switch student to private school. Do equities favor district? I don't know if this is a current case. I'd rather not that we not comment on current cases, but if you generally want to comment on that, Mark, feel free.
The one thing the only comment I guess I'd make is that the statute talks about time of removal rather than time of enrollment. So really the key thing with regard to the notice provision anyway would be when the child's being removed.
Okay. I don't have anything more.
Great. Okay. Let's move on to the next slide and the next topic. So, there is the provision in the statute about risk of physical harm and when that will excuse compliance with the 10-day notice provision. Again, I was kind of looking for illustrative cases along these lines. A realistic danger of a child's suicide does fit into this category, it seems. That Fort Bend case is a good example of that. In other situations where you've got really severe emotional disturbance such that the kid is a danger to self or conceivably. Actually, in the JM case, which is out of New Jersey, it was as much a danger to the parent as it was to the kid himself. Then that appears to fit into what the drafters of the statutory provision were talking about. Next question, and this one I think actually was one that Lynn had posed to me when we were preparing this. What if the parent has resisted making the child available for evaluation? Is that a ground on which to reduce or deny reimbursement? And in fact, of course, courts have done that because they've said that the parent was not behaving reasonably by failing to make the kid available for evaluation. Now, you can certainly argue, I guess, in some instances that there could be a severe harm to the child from undergoing another evaluation of some sort, but it seems that that would have to be a quite rare kind of an instance. The case that does suggest that failure to make the child available is that PS against Brookfield case out of District of Connecticut. I'm sure you could find additional cases as well. I thought that an interesting and topic that I'd seen showing up more than I would have expected is the one of, so it's tuition reimbursement. Does that mean there really actually has to be something that's been reimbursed, or could you simply incur the obligation and have payment of the obligation be an appropriate remedy? It's true that the language of the 1412 provision doesn't, speak of that. Burlington doesn't speak of that. TA doesn't really speak of that, but it does seem logical that if it's simply a legally born obligation, that you'd be defeating whatever be the underlying purposes of Burlington if you didn't allow for, quote, reimbursement or payment of that incurred indebtedness. And sure enough, that AW case out of the Northern District of New York seems to make that point quite clear. What's interesting on that one, though, that I don't know whether this causes any concern on the part of any hearing officers or not, but so it was really the private school that kind of self-financed the debt. It isn't as though the parent went off to someplace and borrowed the money, went off to the bank and got a loan. It really was the school. I don't think that matters. That the fact is that the school's foregoing the collection of the debt really is no different from going off to the bank and getting the loan. In fact, if anything, it's probably cheaper in terms of interest for the school to be doing that. The school obviously at that point does have some rather strong interest in having the tuition reimbursement award be entered, but that's probably true in general anyhow. So I don't know that that's a particularly persuasive point one way or the other. You also do have a few cases where somebody other than the parent pays. So in Kirsch, which is that case that we've now brought up for a couple of other propositions as well, the grandparents pay. Yeah, but there are parents in the picture as well. It just appears that they didn't have quite the financial resources that the grandparents did. So do you get tuition reimbursement then, even if there isn't any formal loan agreement between the parents and the grandparents? And the court didn't seem to have a whole lot of difficulty saying, yeah, of course you do, don't bother me with this. So I think that, even if there might be some sort of theoretical problem or something with it, courts are going to try to apply what you might see as a kind of common sense approach on that topic. And then really maybe the final topic that is, just before you get into just reasonableness in general, are the things that are on this slide 20, and really the next slide as well, slide 21, which I'm going to advance to just for a moment. So how open does the parent have to be to the public school system's offer? And if you make an arrangement with a private school, is that going to be an indication that you're not sufficiently open to the offer, that it's going to be viewed as unreasonable conduct on the part of the parent? So the cases that seem to be most relevant here, there seem to be plenty of instances where the parent is simply intransigent and doesn't seem to be at all receptive, and the courts hold it against them. The Fifth Circuit case that I've got there is probably one of the better known, but I'm sure you can find plenty of others. But oh wait, I did cite NR now that I look at it, for something other than what our commenter mentioned, or maybe not exactly what our commenter mentioned. The NR case does say that simply maintaining a firm view of what the child needs and listening but not agreeing with what the school district does or what the school district says, is not a basis on which to reduce or deny reimbursement. And, if you're of that view, or if you're adhering to a firmly held view that that's what the kid needs, it would not be, of course, surprising if you would have made a prior arrangement of some sort, and that then might come up as either evidence that you're being intransigent as the parent, or perhaps that perhaps simply as an indication that you as the parent are being cautious because you don't want to lose a place on a wait list because you failed to put in a tuition or failed to sign a contract. So the SC against Katona case is, I hope I'm pronouncing that correctly, I think I am, is a good instance where the court says, yeah, simply with the fact that you signed the contract doesn't mean you weren't willing to listen or weren't willing to compromise. After all, if you don't do that, you're highly likely to lose the enrollment slot, especially if you're getting close to August and the beginning of the school year. The Board of Ed against Bauer case from out of the area sort of makes the same point at a little greater length. There's a DC case, Leggett, that says roughly the same thing, the DC Circuit, and a District of Connecticut case, all of which kind of emphasize the idea that the mere fact that you've made the arrangements doesn't mean that you're being intransigent or that you're not being open. But I do think that Lynn's point is a very important one here, that what you have to do is make sure that if you are finding that there's intransigence or unreasonable behavior, make sure that the record is quite clear as to why it is you think that way. If the parent has inked a contract and you don't think it's important, then again, reasoning or evidence that supports that certainly should go into the program or into the opinion as well. So what other things could come in or could possibly be of issue here? Just good faith in general seems to come up a fair amount. That LK case, which actually in some ways seems to be complaining as much about what the Supreme Court and the drafters of the congressional provisions here have done as anything, is saying, yeah, you just have to make a determination out of good faith, and that's an issue of fact, and you have to figure that out. It could be, however, that you still will wind up making reductions even when people are acting in good faith, if what they've done is gone out and purchased services that are beyond what the kid actually needs in getting appropriate education. And the LK case is, I think, a good example of where the court felt strongly that that was the situation that applied there. One where you've got some things that really did seem to go beyond what the court felt was appropriate. Although, interestingly, and I think that this maybe is a good note on which to kind of close out the point, the LK case did point out that everything costs more in New York City. It's kind of the land of the $30 hamburger. So it wouldn't be surprising that the costs might be high if they have to be obtained in a market like that of New York City. I guess we got probably enough time for a question or two.
Well, let me offer a comment. The why questions with regard to equities, I think, are important ones to potentially ask. Why didn't you give the notice? Why did you pick that school? Or how did you go about looking at private schools. And why did you pick a school that was so far away? Was there one closer by? I mean, a lot of those why questions can give you the basis. Could cut either way in terms of the response, but it gives you a basis on the record to make an equities determination.
Yeah, that's helpful. Okay, Steady, were there other questions from the?
There's one thing I just want to point out. I know you focus on the reduce or deny of likely resort of physical harm to the child, and that seems to be if you find that that is happening, it must not reduce. But there is a section also that speaks to serious emotional harm to the child, though that is couched as may, and I never understand why they make that distinction, but they made it nonetheless.
Yeah.
It's 8 o'clock, so let's go to the last slide and put the code up. I like to end on time. Code number 5 is up there. There are a few comments and questions which I'm happy to cover, but for those of you who need to sign off, you've met your requirement. Code number 5 is up on the screen. I do want to thank you all. This is the last of our webinar series for our contract year. Next time we meet again will be in the fall, in October, with the dates already having been published with respect to the on-site services. So with that up there, I just wanted to just go over what if the parents' intentions change. So initially they decide to do a private placement without seeking reimbursement, and then 1 year later or 2 years later, they decide the student still needs to be there, and therefore they're looking for private placement to go back 1 or 2 years plus 1 year. Would that be a potential excusable basis for lack of parent notice?
You know, the times that I've seen that argument made, at least any time that I think I've seen it made successfully, it's usually coupled with a child find objection. You know, so the parent is basically saying we didn't give notice because the school district didn't fulfill its obligation and determined that the kid had a disability or didn't do the assessments, or otherwise kind of placing it back on the school district. Otherwise, I think there would be some difficulties.
The last question I have is, can we go further into good faith when contract has been signed?
I wish I could. I don't have a lot of authority on that specific point. There's that Gustafson case, there's the LK case, and both of them do wind up citing a few other cases in the course of making their decision. That GB case, if I remember correctly, has good, interesting language, but I don't think I found the facts all that illuminating. So I wish I had more to offer you on it, but I'm not sure I really can.
Okay.
I guess I'm with Judge Nathan in saying that I wish that somebody like either the Department of Ed or Congress or the Supreme Court or someone would give us a little more guidance.
Mark, I want to thank you for these last 2 hours. Lynn, thank you for your participation as well. Folks, thank you.
Thanks to the group.
We will gather again in the fall. Have a wonderful rest of spring or / summer, and we will see each other soon enough. Bye-bye.
Okay, thanks.